Mr. Raman, just a minute. Umar कितना है इसका? Please take your seat. Yes,
Yeah, please proceed. Proceed. I have to mention.
just a minute. You are mentioning before single bench or division bench.
Division bench.
Your item matter relates to division bench or single bench.
This one, item number 26.
No, single bench.
Single bench.
Yeah, and you have seen we are in DB. Why are you mentioning now?
My lord.
Yes, Mr.
Your lordship. This is a review petition, my lord. And before your
Let
lordship,
us see what are the grounds for review.
my lord, we have some new grounds here, my lord. Can I, your lordship?
Can you take the new ground?
My lord,
Let us see what are the grounds for review.
my lord, the new ground, my lord, is that this one document, page number in the main petition, my lord.
Let us see your grounds.
My lord.
What is the review?
Page number 11, my lord.
Of the review petition.
My lord.
Yes. Yes.
My lord, one of the ground is that one of the most important ground is that we could not annex this reference case before your lordship, where it was mentioned that the petitioner was accused of entering India illegally between 1966 to 25th of March 1971, my lord. So that was not before your lordship, my lord. Now we have annexed those documents. Subsequently, after your lordship dismissed the writ petition, my lord, we were given this document and it's before your lordship. The inquiry report form 1, 2, and 3, my lord, it says post 1971, but my lord, the reference case which was sent, my lord, if I may take your lordship through page number 38 is the type copy, my lord. Sorry, 85 is the main copy, my lord. Page number 85. The notice also says between 1/1/1966 to 1971, my lord. 9 के बाद में क्या देखा? 9 के बाद में- हम्म, हाँ इधर रहने का, इधर 8 नहीं खाते, 8 नहीं, 8 क्या है?
Please come to page number 100.
My lord,
Inquiry officer's report,
my lord,
page number 101,
my lord,
serial number 18.
my lord.
Kindly read.
Yes, my lord, that's what I submitted, my
Kindly
lord. After, what are the pleas of the person? Does the person claim to be Indian citizen? Yes. A foreigner but entered into India after 1166, after 25th March 1971. Lord, form 1, 2, and
Form, the serial number 22.
my lord. During inquiry, it appears to me, the prima facie manner that Anwara Khatun, in respect to
Is
be
suspect,
to be an illegal migrant, as she entered
illegal
into
foreigner.
India post 25th March 1971. Hello.
Then this is the report down below.
It
Conclusion.
appears to me in a prima facie manner that the suspect, Muhammad Anwara Khatun, 40 years, is a foreigner who entered into India illegally. Hence, the case is referred to FT
Now,
Nalbari.
then please come to page number 93.
Hello.
Inquiry officer's report. in
Yes,
form
my lord.
2. Now come to page number 94, serial number 12.
My lord. Serial number 12, yes. If the person entered India without a passport, how the person entered through unauthorized route, name, village, district from which the person entry uh, after 25th March 1971.
Come to page number 89. Serial number 11.
11, my lord. Since when she is staying continuously in India, 25th March 1971. After
Serial number
25th
18.
Inquiry officer report, in this report, inquiry officer should make specific remark of his finding whether the person is 1966-71 foreigner with reason or he is a post 25th March 1971. During inquiry, it appears
To me,
in a prima facie manner that Musammat Anwara Khatun is suspect to be an illegal foreigner as she entered into India after 25th March 1971 without valid documents.
then come to page number 105.
My lord.
Or 104. 105.
105, my lord. 105.
Somebody has underlined 01/01/1966 to 24/03/1971. But on the side, you'll see there is a tick mark. That
My lord,
that
this is
indicates 24 after 24th of March 1971.
not. My lord, there is little confusion on this, my lord, whether it's a tick mark or a strike
When
it
the
down.
report is after 25th of March, why the tribunal will do that? Anyway,
My lord, in the reference case, if I may take your lordship through the reference case, which is page number, my lord, 83, my lord. The original one, my lord, 85, my lord. 85, my lord.
yes.
85, my lord. Here, I have gone through the inquiry report of suspect foreigner so and so, submitted by SI Gajan Das during suspect Musammat Anwara Khatun appears to be a foreigner. He entered after 1st January 1966 before 25th March 1971 illegally. Lord, here it is different, my lord. Even in the notice, my lord, they have underlined it, my lord. Underlined 1/1/1966 and
When
24th
the
March.
inquiry report is after 25th of March 1971.
My lord, so that's why I'm before your lordship, my lord. I have annexed everything, my lord. It's not that I have not annexed it, my lord. I have annexed all the 3 inquiry reports.
Now she got the opportunity to appear before the tribunal.
My lord, she got the
She
opportunity.
did not avail.
My lord, so in
It is
that
not
case,
that she didn't get chance.
my lord,
Right? She
my
did
lord.
not avail.
My lord,
She was
your lordship
fully
is correct.
aware. She was fully aware of the proceeding was pending against her, and she was supposed to appear.
My lord, your
She
lordship
did
is
not
correct.
appear, Mr. Raman, please listen.
My lord.
She did not appear. Whatever done, she has engaged a lawyer. The lawyer took time on behalf of her. She never appeared before the tribunal.
My lord.
Ultimately, lawyer stopped appearing.
My
And accordingly, an expurgated order was passed.
lord.
Knowing fully well that a case is pending against her before the foreigners tribunal,
My lord.
she never even bothered to inquire about it.
My lord.
Look at her audacity.
My lord. My lord.
When there was a proceeding before this court, a coordinate bench inquired from the state of Assam. How many foreign nationals being found by the tribunal you have expelled from India? In that circumstances, the government of Assam initiated a proceeding to arrest many of such foreign nationals declared by the tribunals. In that circumstances, this petitioner was arrested sometimes in September 2020.
October, my lord.
October 2020.
31st of October.
Thereafter, they had chosen to prefer this writ petition. Now, probably you are aware of the law of acquiescence. Tell us, why should we review this order? Where is the illegal?
My lord, I would very respectfully beg to submit, my lord. Today, the review petition.
Law means for whom? Who helps the law?
My lord.
Who can get the benefit of law?
My lord. So, today I am producing before your lordship the Rahim Ali judgment. I beg before your lordship that the entire thing should be decided in the light of the recent Supreme Court judgment, my lord.
See, that will be not, that judgment is not retrospective.
My lord, this is in this case also, my lord. Rahim Ali did not appear before the tribunal, my lord. He did not appear before the tribunal. Even before the Guwahati High Court, he produced some document which came out to be not original, my lord. Despite that fact, my lord, I would like to take your lordship through this judgment, my lord. And another fact, my lord, I have filed an IA. My lord, is correct that the petitioner did not appear before the tribunal. My lord, she is in detention since 262 days, more than 8 months.
That's not our lookout.
My lord, she
We
has,
are concerned whether the petitioner had availed her chance.
my lord, she deserve it. She deserve an opportunity. She have already gone through a lot, my lord. 63-year-old woman, my lord.
When she was running away,
My lord,
when she did not
had she
appear,
ran away, my lord, she would not have been arrested, my lord. She was at her home. These are, my lord, very poor, rustic women, my lord. Even the Supreme Court have
that thing
acknowledged this. My lord.
poor rich will not come. A foreigner is a foreigner, unless
My lord,
you
my
are a
lord.
citizen of India.
My lord, I would like to take your lordship through this judgment, my lord. Please, your lordship, please give me this opportunity. Page
Just
number
a minute,
36, my lord.
just a minute. Take your seat.
My lord.
My lord, the record is with me, my lord. The record is,
Mr. Pan,
yes, record is with me, my lord.
let it be.
Only your lordship may kindly see the
Just
notice.
a minute. Let us go through this judgment of the Honorable Appellate Court. Yes. Have you gone through this judgment? Till date, all those writ petitions been decided by this court
Yes.
regarding the foreign industry. Whether will sustain after this judgment.
Lord,
Have you ever gone through and discussed?
yes, my lord, the government of Assam is preparing to file a review petition. And in the instant case, my lord, it's already under.
Go through the Sarvananda Sonowal one
Yes, my lord, this is absolutely,
and also go through this particular judgment.
I'll not comment on that, my lord.
No, nobody should comment.
Yes.
Nobody is
I'll not
required to
comment on
comment.
that.
Go through the Sarvananda Sonowal one, the findings, the observations, and go through this particular judgment.
In fact, if I may submit, my lord, the judgment has,
No requirement of
Yes.
submission. Then we have to wait,
yes, my lord, let it-
and this judgment was passed already when
on 23rd, my lord.
made a quite sensation, came out in newspapers, came out in all the websites. Now, we don't know what will happen. Whether this is to be followed or Sarvananda Sonowal one is to be followed. Sarvananda Sonowal one is by 3 judges bench. And we do not know at this moment because the direction is of the Honorable Apex, but we have to follow as a High Court, right? So in that case, all these years, from the days of Justice V.K. Sharma till now, if it is having that effect, up to the government to
Government has taken a decision, my lord, to file a review. That is understood. And in fact, my submission is that by as my lord did that the Sarvananda Sonowal judgment was just of the larger bench. So that should be,
we are not saying anything on this at this moment. But thing is this, what we have seen. Here is a case, Rahim Ali. It was the proceeding when the IMDT Act was in.
yes, my lord.
Now, has been laid down by the lordships in this case of Rahim Ali. There has to be an inquiry
Prior
under
to,
section 9. So the entire act to be read in a different manner now.
yes, my lord.
So in that circumstances, all those judgments passed by this court following the provision of section 9 of the 1964 or order, 9 of the 1964 order.
Everything will have to go
So back to those days again.
back to IMDT, my lord. Again.
So basically, that we do not know. That was, I was just thinking.
Yes, my lord,
And this
that's
time
fine.
we just look going to the provisions of the Sarvananda Sonowal one.
This,
Because the lordships have to lay it down. So we have to follow. But only thing is probably that inquiry proceeding under order 9 here will be totally different. Leave it to you. But one thing, this particular judgment did not specify
yes,
that it will have retrospective effect.
secondly, my lord, in the instant case, what my submission is that the Honorable Apex Court may do something, my lord, in their capacity. But the under review jurisdiction, can your lordship interfere now?
No, that will not come.
Yes,
That's why we have asked for the grounds of review.
yes, my lord.
Once a petitioner given an opportunity, that was a case, the Rahim Ali's case is little different
Yes,
than
ma'am.
this case
Then Honorable Apex Court
Because-
remanded back, my lord, for
for fresh consideration.
fresh consideration. It was considered thereafter only the Honorable Apex Court has
Right.
passed that order.
Here the petitioner, because the law of acquiescence will come,
That's true.
got the opportunity
She got enough opportunity.
and did not approach the appropriate court at relevant point of time. And only after her arrest, she is now before the court. Whether in that circumstances,
Yes, this is totally
Court should
different,
interfere.
different circumstances.
that's the point of law. And whether we should review it or not.
Yes,
Yes, Mr. Raman.
My lord, can I take your lordship through the judgment, Rahim Ali? Can I take your lordship through the judgment of Rahim Ali?
Sure, why not?
My lord. My lord, from page number 31, my lord.
Hmm.
You have a copy.
We have seen,
Page number 31, my lord.
Hmm.
May I read, my lord?
we have seen that. That's why we read, that is the reason we are talking about.
My lord. Now, my lord, it is not, I mean, even it's not mentioned about the retrospective effect, my lord. When does the burden of proof shift, my lord? Now, when the material basis is given to the petitioner, my lord, even in the notice, my lord, it is not this Rahim Ali judgment which is saying about mentioning the main grounds.
See,
The
that
main ground is
Rahim
statutory
Ali's
provision,
case
my lord.
is, see, totally different. A similar case, the court found
My lord.
the medical certificate incorporated or annexed by the petitioner itself was
Fake, my lord.
fake,
My lord.
forged.
My lord.
On that ground, it was, the writ petition was dismissed
My lord.
because the petitioner wanted to take a benefit of forged document before, by filing it before the court.
My lord.
That was accepted by the Supreme Court.
My lord.
But matter relates to a right of a person, so they considered,
My-
even otherwise,
My-
demanded the matter not to the High Court but straight to the tribunal.
To the tribunal.
The petitioner appeared
My lord.
and the decision followed in that way.
My lord.
Right. So here is a case. The petitioner did not avail the right. Can he or she again avail the right?
My lord, that's why, my lord, that's why I'm praying before your lordship that what the Supreme Court has done. Your lordship
Approach the
may,
approach court,
may,
the
may,
apex court, nothing here.
my lord, your lordship may,
Go and approach the apex court.
my lord, your
See,
lordship may remand back the
That
case.
is
my
the
lord.
reason we are saying the application under section Article 32 is totally different and Article 226 totally different. That's how the Honorable Apex Court, how the constitutions of India has given that power under Article 32 to the Honorable Apex Court, not to the High Court.
My lord, but the precedent that has been set by the apex
See,
court, my lord, that
Mr.
need to be
Raman,
followed, my lord.
You have a
My
right
lord.
to approach against this order to the Honorable Apex Court. Get an order
My
from
lord,
the Honorable.
my
Apex
lord,
Court, we have
when
nothing
the
to
apex
do.
court has,
But we are on that.
my lord.
We are on that. If a person is given a benefit, is given an ample of chance, if he doesn't take a chance and approaches the High Court only after arrest,
My lord.
where is the law of acquiescence?
My lord, then there is also
Where is the law of
natural
acquiescence?
justice.
On
my
what
lord.
provision of law we should allow this
My lord,
petitioner?
there is also, my lord, the law of natural justice, my lord, where even this Rahim
That
Ali
means
case,
everybody can defy. Is not
My
the
lord.
tribunal, is a quasi judicial authority? Was not it is a duty of the person who received the
I
notice
agree,
to appear?
I completely agree. May I
And look
submit
at the audacity of the petitioner.
my lord.
Look at the audacity. That is why I said in the judgment, it's a mockery of judiciary. Why?
My lord, the
Look at
ground
the
reality
entire
need to be
petition.
appreciated, my lord. May I submit, my
Petitioner
lord?
never said anything. That's you are sorry. Says he could not approach.
My lord, we have already mentioned, my
Mr.
lord, because
Aman,
it
sorry.
is the poverty
Where is
of the petitioner that
We are
has
not.
held her back, my
We
lord.
are not
It is
saying
because
whether
of the
it is
poverty, my lord.
rich or poor. Right is right.
My lord, at the end of the day,
Whether
she
it
need
is
to
a
pay
right
the
for
lawyer,
the
my lord.
rich
She need to
people
pay the
or right
lawyer,
of
my
a
lord.
poor people. Right will remain as a right.
To an extent, the lawyer appeared before the tribunal. When he couldn't pay, my lord, this ground reality need to be appreciated.
She could have approached the district
My lord,
level
if the-
services authority.
My lord, I completely agree with your lordship's proposition, but then, my lord, the
See,
law of
which
natural
one-
justice also need to be accepted, my
You
lord.
want the court of law to follow a particular law, right? Go and approach the Honorable Apex Court.
My lord, the honorable apex court has set a precedent, my lord.
No, go and file and let this
My lord,
order
this
be
honorable
discussed
court-
and demand the back matter. We have nothing to say, but see, there is a law of acquiescence. When the petitioner, after
My
getting an opportunity,
My lord,
did not take the chance and see how she was running away.
my lord.
It is not that she was not aware the order was passed expertly against her. But in spite of that, the order was passed. She roamed freely. Only after arrest, her arrest, she realized, no, I should now file a writ petition. That cannot be, Mr. Raman.
My lord, I would like to produce
It is
another
the
judgment of your
fact that
lordship.
he could have straight away after the order of the expert, he would have approached the tribunal. Because of poverty, I could not approach the court earlier or the read court at that point of time. Why only after her arrest?
My lord, on that account, my lord, the petitioner has suffered 8 months in detention, my lord. 63-year-old woman, my lord. My lord, this is now, it has become a question of life and death, my lord. My lord, the life expectancy in India, my lord, is 70 years. She is
Mr. Raman,
63-year-old, my lord.
Don't make those kind of summation here.
My lord, it's a
Make
it's a
legal
question of life and death, my lord.
Now, once the law of acquiescence is there, tell
My-
us.
My lord,
Which
it's a question
provision
of
law
it's
is
a question of life and death, my lord.
We should consider it on humanitarian ground.
My lord, the
under which provision of law?
Honorable Supreme Court in another case have stated that after 2 years, these detainees need to be released, my lord.
Let her
After
be
2
there for
years,
2
my lord.
years.
Now, my lord, it's a question of life and death. She is suffering there. She is sick, my lord. My lord.
There are medical facilities.
Yes, madam.
My lord, I have also,
Consider in
my lord,
such
I have
manner.
also filed an IA, my lord. I have also filed an IA for her release, my lord. I have also filed an IA, my lord.
First of all, review has to be considered, then we will consider the time.
My lord, I would like to take your lordship through the page number 11, my lord. Page number 10, actually, my lord. Justice Arijit Prasad judgment, my lord. Page number 10, para 17, my lord.
Yes.
May I read, my lord?
Yeah.
My lord. How then have the principle of natural justice has been interpreted in the courts, and within what limits are they to be confined? Over the years, by the process of judicial interpretation, 2 rules have been evolved as representing the principle of natural justice and in judicial process, including there in the quasi-judicial and administrative process. They constitute the basic elements of a fair hearing, having their roots in the innate sense of the man for a fair play and justice, which is not the preserve of any particular race or country, but is shared in common by all men. The first rule is nemo judex in causa sua, or nemo debet esse judex in properia causa sua, as stated in so and so, that is, no man shall be judged in his own case. Coke used the form of aliquis non debet esse judex in properia causa, quia non protects esse judex at pers. So and so, that is, no man ought to be judged in his own case because he cannot act as a judge and at the same time be a party. The form nemo protest as a simul actor ad judex, that is, no one can be at once suitor and the judge is also at times used. The second rule is audi alteram partem, that is, here the other side. At times the and particularly in continental countries, the form adjutor at altera pars is used, meaning very much the same meaning. The corollary has been deduced from the above 2 rules, and particularly the audi alteram partem rule, namely qui aliquid staturit perte in naudita alteram actquam licit dixerit. Next page, my lord. Hod acum facerit, that is, he who shall decide anything without the other side having been heard, although he may have said what is right, will not have been what is right. My lord, your lordship proposition of the law of acquisition is correct, my lord. What about the law of natural justice, my lord? In the Rahim Ali case, it has been deliberated on this point also, my lord. My lord, in the Rahim Ali case, lord, there is a witness. May I submit, my lord?
Kindly tell us one thing,
My lord.
whether this is a case where there is a violation of natural justice.
My lord, it is a case of violation of natural
Why?
justice, my lord. I
She
should
got
have been,
an ample of chance.
my lord, there is 2 points, my lord. One, there is an investigation officer, my lord. 2, there is a witness. May I take your lordship for
Was
page?
that an issue in the writ petition?
My lord, page number, my lord.
Was that an issue in the writ petition?
My lord, that we did not have this document. That's why you filed this review petition, my lord. My lord,
And
page number
secondly-
101, my lord.
Hmm.
Page number 101 of the review petition, my lord.
Yes, you have seen that. You have already shown it.
21, my lord, 21. It says statement of the witness enclosed. My lord, where is the
Page number?
witness examined in this case, my lord?
Page number
Page number 101
of,
of, my lord, my review petition, my lord. My review
Yes.
petition. I think this is inquiry report form number 3, probably. It's item para 21, my lord. It says details of the document, oral and other evidence list to be attached. Statement of the witness enclosed, my lord. There is an IO who investigated the case. There is a witness whose statement is enclosed.
In
Where
that
my
report.
lord, where is my procedural safeguard, my lord?
That was.
Where is
in
my
the report.
procedural, my lord? Even in the Sarvando Sonwal 2, my lord, it talks about procedural safeguard. I would like to take your lordship through Rahim Ali's case, where Sarvando Sonwal 2 has been verbatim quoted, my lord. Page number, my lord. My lord, page number 54 of Rahim Ali judgment.
Yes.
Page number 54, my lord. Para 49.
Yes.
My lord, in Sarvando Sonwal versus Union of India 2007, 1 SCC 174, here never referred as Sarvando Sonwal 2, it was held. There cannot be, however, any doubt whatsoever that adequate care should be taken to see that no genuine citizen of India is thrown out of the country. A person who claims himself to be a citizen of India in terms of the Constitution of India or Citizenship Act is entitled to all safeguards, both substantive and procedural, provided for therein to show that he is a citizen. My lord, where is my procedural safeguard? In the inquiry report, it is written that I claim myself to be an Indian citizen, my lord. There should be some kind of procedural safeguard. Where is it, my lord?
Just a minute. Just. That's- Come to page 101.
My lord. Please, your lordship.
Para 18,
My lord.
serial number 18 and serial number 19.
My lord. What are the plea of the person? Does the person claim to be an Indian citizen? Yes. A foreigner but entered into India after 1166, after 25th 1971. What is the evidence on which the person seeks to rely in support of the plea? Furnish particulars? No. Now, had I been approached, I would have submitted this document, my lord. If I was approached, my lord, I would have submitted this document, my lord. In every case, your lordship has been deciding, my lord. All the inquiry report says he has no document. When he goes to the tribunal, he has every document, my lord. How come in no cases there would be any document, my lord? But in the tribunal, the petitioner finds all documents. In the from the investigation process only, my lord. In a very arbitrary manner. In many cases, they don't even approach this petitioners, my lord. And when it comes before the tribunal, my lord. Now, this is my point, my lord. There should be some procedural safeguard. Of course, the burden is on me. The Rahim Ali case says that there should be some material basis, and then only the burden shifts on the petitioner. But, my lord, there should be substantive process. In the Rahim Ali case, the IO was investigated, produced before the tribunal. In this case, was the IO produced? Was the witness produced, my lord? These are the procedural safeguards, my lord.
That is not necessary at all, my lord. In fact,
My lord, that's what the Sarvanda Sonowal says, my lord. Sarvanda Sonowal
Sonowal has said it is not.
That's what Rahim Ali, in the Rahim Ali case, it
We are
says, my lord.
supposed to see whether the order of the tribunal is bad or good. That much. We are not in a writ petition of that nature. We are in a writ petition of certiorari. Prove that the order of the tribunal is bad. Prove
My
it.
lord, that is my whole argument, my lord. Whether the order of the tribunal is bad, my lord. I could not appear. I have given the reason why I could not appear. And then did the tribunal invested on the procedural safeguard, my lord?
That is up to you.
My lord, that is upon the tribunal, my lord. How can I, my lord, how the procedural safeguard is on the authorities, my lord.
Mr. Raman,
It is not on me.
Mr. Raman, after receiving the notice, if the petitioner doesn't appear, whether the court in exercise of the power of certiorari should look into all these aspects, or is it the law laid down by the Honorable Apex Court while exercising the power of certiorari?
My lord, I am going even before that stage, my lord. When the natural justice has been violated, that's what the Supreme Court says, my lord. That's what the Supreme Court said, that the procedural safeguard has not been abided, my lord.
The difference of Article 32 and Article 26 lies there. The provision of Article 32 as per the Constitution, you see, it is the Honorable Apex Court has the right to give the full relief, which the High Court cannot under exercising a power under 226. And we are exercising the power here only under certiorari.
My lord.
So
There is another judgment I would like to
whatever
take
you
your lordship
say,
through, my lord.
whatever you say, it can be considered only under Article 32, but we are not here to give you full rights, only here to see that the law, the order passed by the tribunal is bad or good, that's all.
My lord,
In fact, my lord, this is review petition. Review will have to see whether the earlier judgment of this honorable court was, my lord, there is any error apparent on the face of the record. We cannot interfere, my lord. We cannot go for rehearing of the writ petition, my lord.
That
So
will-
we have to confine in the review jurisdiction, my lord. We cannot go here and there, my lord. We have to confine in the review
inadvertently,
jurisdiction.
if we could not
whether-
produce any document, my lord.
That has to be, so come to that point only. You cannot go beyond that. In the review jurisdiction, you cannot argue the new case, my lord. The writ case, my lord. He can argue this, that will not do, my lord. come to the review jurisdiction. If he has any, my lord, ground, then he will succeed. If he has no ground, go to the apex court, challenge the, my lord, original order. We have no bar on that. But if he is arguing on the review jurisdiction, he have to confine in the review ground, my lord. He cannot go beyond that.
My lord,
Review is very restrictive, my lord.
my lord, this judgment, my lord, Jagmeet Sen Bhagwat versus Director of Health Services, Haryana and others, para 7, my lord,
Yes.
para 7, page 2, my lord, para 7. It says, indisputably, it is a settled legal proposition that conferment of jurisdiction is a legislative function and it cannot neither be conferred with the consent of the parties nor by superior court. And if the court passes a decree having no jurisdiction over the matter, it would amount to nullity as the matter goes to the root of the court. Such an issue can be raised at any stage of proceedings, my lord. Lord, any stage of proceeding.
See, you are placing.
My lord, this is also referred by the full bench in the Mujibur Rahman case, my lord, by this honorable court, my lord. But at any stage of proceeding. Mujibur Rahman.
Yes, let us see the grounds of your review.
My lord.
Number 11. Yes,
My lord, may I read, my lord?
yes, please.
From para E, my lord?
Read from A.
My lord, because the Honorable High Court ought to have considered the evidence and exhibits brought on record by the petitioner herein, because the Honorable High Court failed to appreciate the evidence and exhibits in proper perspective and passed the impugned judgment without applying a judicious mind and erroneously declared the petitioner to be a foreigner under Section 2A of the Foreigners Act 1946. Because the Honorable High Court failed to appreciate the petitioner is a citizen by birth by virtue of 3(1)A of the Citizenship Act. Petitioner was born on 1/1/1970 as she is a citizen by birth. Because the Honorable High Court failed to appreciate that the petitioner being a citizen of India being before 1985 is exempted from the provision of 6A of the Citizenship Act 1950 by virtue of the provision of Section 6A 7A 6A 7A of the Citizenship Act, because the Honorable High Court failed to appreciate that the notice and reference was issued against the petitioner to prove that she was a foreigner of 1/1/1966 and 25th March 1971 stream. But the learned tribunal passed an ex parte order holding that the petitioner is a foreigner of the post 1971 stream. This is judicial overreach and clear manifestation of the non-application of mind by the tribunal, because the Honorable High Court failed to appreciate that the petitioner had no intention to flee the proceeding, but the exceptional circumstances could not allow her to present before the learned tribunal to adduce a written statement referring to Asruddin versus Union of India, because the petitioner has good case on merits and the learned tribunal order dated 23 this is probably an error, my lord. 29 has caused irreparable damage to the petitioner. Mere technicality should not be relied on to deny the natural rights of the petitioner, because the Honorable High Court failed to appreciate the principle of waiver rights as specified in the legal maxim vigilantibus et non dormintibus jura subveniat do not attract in the case, because the citizenship is a public right as envisaged in the Constitution of India, and aforesaid principle is only applicable to private rights emerging from the contracts of two private parties, because the Honorable High Court has failed to appreciate the ex parte order by the learned tribunal will have disproportionate effect on the petitioner, leading its violation of Article 14, 1921 of the Constitution of India.
Okay. Yes, Mr. Pine. You reply.
Yes. But first of all, my lord, my submission is read by the principal. You have to confine with the grounds whatever the petitioner brought before the reasonable court. My lord, my submission is that, my lord, the grounds preferred by the petitioner are not ground for, my lord, good ground for review of the judgment and order which is passed by the reasonable court. The first, my lord, the first ground taken by the petitioner is that because the honorable court ought to have considered the evidence of exhibits brought on record by the petitioner hearing. There was no exhibited documents at all, because the proceeding, my lord, it was an ex parte proceeding. The petitioner did not exhibit any documents before the tribunal. This is totally a wrong submission. So it cannot do. Secondly, my lord, because the Honorable High Court failed to appreciate the evidence and exhibits in the proper perspective passed by the imperial judgment without applying its judicious mind. What is the evidence, my lord, and exhibited exhibits, my lord? There was no evidence at all, no exhibit at all. This is totally, my lord, wrong pleading, in fact, my lord. Because number C is, my lord, because the Honorable High Court failed to appreciate the petitioner is a citizen by birth by virtue of section 318. What is the proof of his, my lord, born? When did he was born? If there are any documents, if there is evidence to show that he was born in India on 1971, there was no evidence at all. On what basis he can say he was born in 1971 if it was not pleaded before the my lord tribunal? Where from the High Court will ascertain these things? Number D, my lord, because the Honorable High Court failed to appreciate the petitioner being citizen of India before 1985 is exempted from provision 6A of the Citizens Act. First of all, he'll have to show that he was born in India prior to 1985. He has not given any evidence to, my lord, before the tribunal. In fact, it is an ex parte order. He voluntarily did not appear before the tribunal. He is saying, my lord, that this Honorable Court has not appreciated the evidence that he was born prior to 1985. Where is the evidence? Mere saying, my lord, mere giving a ground in the review petition that this was not appreciated, this was not appreciated, that will not do. In fact, I'll submit, my lord, these are the,
One after. Finish the grounds, then we'll consider all those aspects. Then next.
because the Honorable High Court failed to appreciate that notice and reference was issued against the petitioner to prove that she was foreigner of 1/1/1966 and 25th March 1971. The record, my lord, that's why I would like to show the record, my lord. The notice is clear, my lord. Notice is clear. It is notice is clear, my lord. My lord, your lordship may kindly produce the notice, my lord. It is clear. It is clear. There is no ambiguity in that notice. And the ground is clearly written, my lord. Ground is clearly written. As you cannot produce documents when he was asked, so you are suspected to be foreigner. So on the grounds aforesaid, you are hereby asked to give your show cause. So ground is clear, my lord. So it is clear, my lord, there was no ambiguity in the notice. And as your lordship has seen, the inquiry also says that he could not produce any documents of prior to 1971.
Okay, then
Then, because the Honorable Court failed to appreciate that the petitioner had no intention to flee the proceeding, but the exceptional circumstances. What are the exceptional circumstances? What is the exceptional circumstance? Everyone is poor, my lord. In all the foreigners tribunal cases, everyone will be found that they will plead that he is poor and illiterate. That means everyone has the right to flee, my lord, everywhere. To, my lord, go away from the proceeding, my lord. That does it mean they have the right to not to appear before the tribunal only on the ground that I'm poor, I'm a little illiterate? It cannot be a ground. It cannot be a ground for not appearing before the tribunal. It is not an exceptional circumstance. What is the exceptional circumstance? Then, my lord, the natural justice. What natural justice has been violated? What natural justice of the petitioner is violated? Natural justice is not a, my lord, one-way traffic. It has to be followed by both sides. She will not appear before the tribunal and she will ask for the natural justice. She will not appear before the tribunal for 4 years. She will say, I need natural justice. It cannot be, my lord. My lord, my argument will be nothing, no natural justice has been violated in the present proceeding. Every, my lord, procedure was followed. In fact, if I say, my lord, what my learned friend argued, that no procedural safeguard was there, there are evidence, there are witnesses, my lord, which has been recorded. In record, it is there. There are 3 witnesses, my lord, who has given their statement before the police. Those are in the record. It is not necessary. This honorable court has given, my lord, the numbers of judgment that grounds may be recorded, grounds may be given in precise. Every documents need not be submitted to them. It is not a normal criminal proceeding, my lord. It is not a normal civil proceeding. It's a question of, my lord, integrity of the security of the state is concerned. A person who is a foreigner will remain in India for 5-6 years without appearing before the tribunal and will say, my lord, who is a threat to the country, will say, my lord, I need natural justice.
okay, next.
Because the petitioner has a good case on merit and the learned tribunal order dated so and so has got irreparable damage to the petitioner, merely technicality should not be relied on to deny the natural rights of the petitioner. What technicality, my lord? He will not appear before the tribunal for 4 years. It is not the technical. It is, my lord, the failure on the part of the petitioner to appear before the tribunal. He has suffered the consequence. He has suffered the consequence, my lord. And this has been considered by this honorable court, my lord. After considering everything only, this honorable court has passed the, my lord, the order which is under silence in the review jurisdiction. Everything has been recorded in the, my lord, the earlier judgment of this honorable court, which is under silence in this review jurisdiction. Then, my lord, because the High Court failed to appreciate the principle of waiver of the right to specify the legal maximum of so and so, do not attract the case. The citizenship is a public right and investigate in the Constitution of India, and the aforesaid principle is only appreciable to private right emerging from the contract of 2 private parties. Does it mean, my lord, the foreigner who will come to India and he will remain in India, he will not follow the, my lord, direction of the court, direction of the tribunal? All this, my lord, all this has been considered in the judgment of this honorable court. And in fact, my lord, the petitioner has not said the tribunal, the opinion of the judgment of this honorable court is error, and there is, my lord, error apparent in the face of the record, or anything in the, my lord, in the judgment of this honorable court. In fact, they are praying, my lord, the rehearing of the, my lord, writ petition, which was dismissed by the honorable court. There is no other ground.
Yes, want to place anything?
My lord, the jurisdiction of the review, my lord, review jurisdiction of the court. Numbers of judgments are there, my lord, but I would like to rely, my lord, the two judgments. That is, my lord, Kamalesh Burma versus Mayawati and others. 2013 8 SCC, my lord, 320.
320.
Yes, ma'am. There everything is discussed, my lord. When review is review will lie and when review will not lie, my lord. My lord will find discussion from para 8 onwards, my lord.
Para,
Para 8 onwards. In fact, here, my lord, the review jurisdiction under Article 137, para 9, it is said, my lord. Article 137 of the Constitution of India provides for review of judgment and orders of the Supreme Court, which reads as under. This is, my lord, Supreme Court's. Your lordship may kindly see from para 12, my lord. Details discussion is from para 12. The court has repeatedly held in various judgments the jurisdiction and scope of review is not that of an appeal, and it cannot be entertained only if there is an error apparent, and it can be entertained only if there is an error apparent on the face of the record. A mere repetition through different counsel of old and overall arguments, a second trip of ineffectually covered grounds, or minor mistake of inconsequential effort are obviously insufficient. This is clear, my lord. The Honorable Apex Court has relied, my lord, another judgment, but I'm skipping those, my lord. Then your lordship will find para 13, my lord. This para 13. In a criminal proceeding, review is permissible on the ground of an error apparent on the face of the record. A review proceeding cannot be equated with the original hearing of the case. In Northern India, Caterers versus Governor Delhi, the court in para 8 and 9 held as under. My lord, this is also elaborately it is discussed, my lord. Then your lordship will be in para 14, my lord. These are the main points, my lord. Para 14. Review of the earlier order cannot be done unless the court is satisfied the material error manifest on the face of the order undermine its soundness or results in miscarriage of justice. Then, my lord, para 15. An error which is not self-evident and has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court to exercise its power of review. A review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected, but lies only for patent error. So my submission is, my lord, if my learned friend is not satisfied with the judgment of this honorable court, they can very well go before the Honorable Apex Court or higher authority. But in review, they have to come with a clear case that there is error apparent on the face of the record in the judgment passed by this honorable court. Where is the error apparent? Then, my lord, para 16, error contemplated under the rule must be such which is apparent on the face of the record and not an error which has to be fished out and searched. It must be an error of inadvertence. The power of review can be exercised for correction of a mistake, but not to substitute a view. The mere possibility of two views on the subject is not a ground for review. Then, my lord, it has. Then para 17, my lord. In fact, in that point, my lord, numbers of judgments has been discussed earlier, judgments of the Honorable Apex Court. Then para 17, it is said, in a review petition, it is not open to the court to reappreciate the evidence and reach a different conclusion, even if that is possible. Even if that is possible, the Honorable Court will not reappreciate the evidence, madam, and reach a different conclusion, madam. The conclusion arrived at one appreciation of evidence cannot be assailed in a review petition unless it is shown that there is an error apparent on the face of the record for some reason akin thereto. Then para 18, my lord, review is not rehearing of the original matter. My learned friend want the matter to be reheard, that this has been done, this was not done. This cannot be done. Review is not a rehearing of an original matter. The power of review cannot be confused with appellate power, which enables a superior court to correct all errors committed by the subordinate court. That's why I'm saying, my lord, if they are not satisfied with the judgment of the Honorable Court, this Honorable Court, they can go to the apex court. But it is not under the review jurisdiction. It cannot be challenged under review jurisdiction. A repetition of all and overall argument is not enough to reopen concluded adjudications. Whatever argued today, my lord, that this was not done, that was not done. He's an illiterate lady, she's an illiterate lady, she could not appear properly. These were argument of the writ petition. And after considering all those, my lord, this Honorable Court has rejected their claim and passed that earlier judgment. And para 19, my lord, it is said, review proceedings are not by way of any appeal and have to be strictly confined to the scope and ambit of Order 47, Rule 1 of the CPC. So we have to confine especially under Order 47, Rule 1 CPC. So these are the grounds, my lord, which the Honorable Apex Court has said. In fact, it is summarized in para 20.1 and 20.2, my lord. Clearly summarized. It is summarized shortly. All these grounds. So my submission is that, my lord, as the review jurisdiction is very limited, the petitioner has no case for reviewing the, my lord, the order judgment passed by this Honorable Court. Whatever is there, if they go to apex court or higher court, that is a different case. But at least for review, it is not a case, my lord.
Yes, Mr.
May I submit?
Yes, Mr. Payan?
Yes, my lord, if necessary, I'll submit later, my lord.
Yes, Mr.
My lord. My lord, in this case, my lord, I am not before your lordship to declare the petitioner to be an Indian. I am just merely seeking a remanding back of this case, my lord. And the entire thing, my lord, the additional ground, my lord, the entire thing should be read with the Rahim Ali judgment. And my learned friend has already stated that the government is contemplating to review the judgment. But till that time, it's not reviewed, the judgment is in effect, my lord.
Mr. Rahman,
It is in effect, my lord.
we are not on that. We are not.
My lord, I'm coming
We are
point
in
by
a
point.
review and we are in a certiorari. That much only.
My lord, my lord, my lord. The judgment that I have read to your lordship, I would like to read the entire para of the judgment, my lord.
Which one?
Because this is, my lord, Jagmitar Zain Bhagwat. The entire para I want to read to your lordship. My lord, may I read, my lord? Para 7.
Yes, yes.
Para 7, my lord. It says, indisputably, it is a settled legal proposition that the conferment of the jurisdiction is a legislative function, and it can neither be conferred with the consent of the parties nor by the superior court. And if the court passes a decree having no jurisdiction over the matter, it would amount to nullity as the matter goes to the roots of the cause. Such an issue can be raised at any stage of proceedings. The finding of the court or tribunal become irrelevant and unenforceable in executable once the forum is found to have no jurisdiction. Similarly, if the court tribunal inherently lacks jurisdiction, accusations party equally should not be permitted to perpetuate perpetrate, defeating the legislative animation. The court cannot derive jurisdiction apart from the statute. My lord, I am questioning the jurisdiction of the tribunal here, my lord. The jurisdiction of the tribunal, my lord. My lord, this is the order. This is the notice, the original notice. There is a little difference. They give us one notice and then they have another notice this is the original notice that has been given to me. And the reference case, my lord, where it says that between 1/1/1966 to 24th March 1971. Although the inquiry report says post 1971, but the reference says this. My lord, how can they question my citizen in such casual manner, my lord? That is what I am questioning before your lordship. That is exactly what I am questioning, my lord.
There is no jurisdictions of the tribunal. And if there is no jurisdiction, my lord, at any stage, my lord, I can question this. And because, my lord, due to some inadvertent reason, my lord, I could not annex this document. In the review, I have annexed this document. And not that I have not annexed the 1, 2, 3 form. I have also annexed that. But there is also the reference case. My lord, they cannot be so casual, my lord. Kindly see the report also. They give us one report, the another report is in the another notice in the report, my lord.
Has no effect on.
And also my friend has said that this 63-year-old woman was a threat to the country. I really wonder, my lord, what kind of threat she was to this country, my lord. I really wonder, my lord.
Not only 63 years old, my lord, it may be 80 years old also. But a foreigner cannot be, my lord, cannot remain in India if she is a foreigner. And who knows, my lord, what kind of conspiracies are there. We have numbers of cases, my lord, where more than 60, 70 years old persons are still coming today.
This is going
from
too far, my
foreigners.
lord.
No, still coming.
This is going
still
too far.
coming.
My lord, another
We
my
have
lord,
reports.
my friend has submitted, there are 3 witnesses, my lord. That is exactly what I am arguing. The 3 witnesses, because this is an ex parte case, my lord.
But it is
Where
not,
is the IO
it
who
is
was
not,
to-
it
Milord,
is not
Milord,
necessary
expert-
to take evidence, my lord. What
And,
the
and it's not that I did not appear, my lord. There are 6 times my lawyer appeared. Subsequently, my
No,
lord,
no,
I could
it
not
is
see
not
the lawyer. my lord.
necessary. It is your burden to prove that first.
My lord, I mean, if you are not talking about Rahim Ali judgment, then what can I do?
No, Rahim Ali has not said that, my lord. I can distinguish that Rahim Ali on that fact, my lord. Rahim Ali has not said that.
These all circumstances are similar, my lord. Entire circumstances are similar.
Not similar, my lord. This is totally different.
And my lord, the notice says that the main ground is, where is the main ground, my
It
lord?
is there in the notice.
This form 1, 2,
It is-
3
it is-
reference case, we are not
it
given
is
this
there in the
form 1,
notice.
2, 3.
May I-
So there is a statutory, this is a statutory thing, my lord. That has been violated.
That is clearly written in the notice, my lord. Ground is given there. These are not the
I
case
would
of
go to the
argument
extent
at the
of
time
saying,
of
my lord, the
review.
Rahim Ali judgment before the tribunal was far more on a better ground than this, my lord, because that I was not investigated, not examined.
That
The
was
witnesses
not the
were not
law.
examined.
That was not the law to be law. That was not the law at all, my lord. That is, in fact, that is not the law at all, as on now. A person will not appear before the tribunal. He will ask for why he was not examined, why he was not called to do for giving evidence.
Not my words,
What
these are
right-
Supreme Court words. What can I do?
No. The full bench of Honorable Apex Court has clearly stated.
Even the Sonwal too says about procedural safeguard, my lord.
Yeah, procedural safeguard is there. The witness, he was asked to give it evidence. He did not come before the my lord police officer.
Heard Mr. AWM.
My lord, one humble submission, my lord. My lord, with folded hand, my lord. With folded hand, my lord. This is the question of life and death, my lord. The petitioner should not die in detention, my lord. 8 months I have suffered, my lord. My IA is there, my lord. Kindly release me from the detention center. This is a question of life and death, my lord. Humble submission, my lord.
The Honorable Apex Court has clearly said 2 years, minimum 2 years. If he is serving for more than 2 years, he will be automatically released. Then it will be a violation of Honorable Apex Court's order.
For the review petition.
If he is relying on the Honorable Apex Court's method order. Those who have served more than 2 years, they can be released, my lord. That is the law by the Honorable
Release
Apex
many
Court.
such people.
Who is appearing for the union? None appeared for the rest of number 1. Election Commission is there? No. Two.
Further, my lord, I will submit, my lord, the conduct of the petitioner is not so good that he can be released. He can be released.
We are on the review. They filed. The new council. For the rest of number 3. 5.
66, 71, or 71, or 80.
Will appear?
I believe they collect jurisdictional. Reference of the particular one.
Notice.
Only one point, my lord, with regard to jurisdiction, as my learned friend has raised that issue. my lord, this honorable court has clarified, my lord, in numbers of judgment, even in the notice, if the, my lord, stream is wrongly mentioned, or my lord, if there is no materials that he was available in state of Assam prior to 1971, that will not affect in any manner. That is
Citation.
clarified. I'll provide the
My case is
citation.
little different because there is a reference also, not just the
The
notice.
reference is clearly, my lord, the investigation has clearly shown that he has
No,
come
they-
after
they should not have made a mistake
25
in the reference, my lord.
Everybody
cannot-
can make
order, please
mistake.
cannot
my
be
lord.
so
No,
casual.
no. It cannot be.
It's a question of citizenship, they cannot be so casual.
It is reference is not clear, my lord. Reference is not said that he has come. This is a format.
So there should-
In the format, it is, my lord, written. It is in fact, it is a format.
So
In
then
the
the
format, it
board
was
will
wrongly
do some
written.
kind of amendment. I mean.
No.
They cannot question my citizenship format.
My lord, the inquiry officer, what inquiry officer says, the SP cannot give of himself, my lord, the report. He has to give the report on the basis of inquiry officer's report. What is the basis of the, my lord, reference of the SP? The, my lord, report of the, my lord, inquiry officer. What is the report of the inquiry officer? It is post 71. So everything has to be considered by the tribunal.
Including the reference.
What is there in the material? He has to, my lord, this is.
Very recently, we had a conference at, it's a regional conference. Earlier it was, last year it was held in Guwahati.
My lord.
Last year it was held in Guwahati, this time it was held in Kolkata. Honorable Chief Justice of India pointed out before the people there, because all the judges from the Northeast are there, also from the Honorable Apex Court, many judges were there. Regarding the citations we make in the judgments or in the, by the lawyers, it was pointed out by His Lordship, the Chief Justice of India, that judgments are from the Supreme Court or from the High Court. But these journals, they used to edit it. And they are selling it to the lawyers or the courts at a higher price. And that is why it was very specifically mentioned that it's available in the site. All these judgments passed by the Apex Court are uploaded every day. That has to be considered. That is, of course, without any head note. And with head note, it comes after a week, which is free. So that is specifically mentioned by His Lordship, the Chief Justice of India. So you can also go through in the websites to see, because what Mr. Raman was placing a judgment of Jagmeet Singh, right?
Manupatra probably.
That is from Manupatra.
My lord.
And sister was reading the Manupatra version has been given. I was going through the SCC. Now the paragraphs have changed.
Yes. In SCC Manupatra, the paragraph changes. Your Lordship is correct.
Because the SCC of their own edits. And they, while editing, they also edits the paragraphs of the effect code.
My lord.
But in other journals, it remains as intact. In Manupatra, of course, the same judgment is given. Only the editorial part is different. So you don't get the editorial part in Manupatra. Same judgment you get. So that was been advice given by the Honorable Chief Justice of India in the last. Go through it. It's a free versions are there in the SCR reports. But like during the deliberation of the matter, Mr. Aman, counsel appearing for the review petition, placed the copy of the notice received by the petitioner. The other hand, Mr. Payam Lanet, Standing Counsel Home Department, listed, placed the entire records of the concern FT case number 42/Paksa, 2009, the London Tribunal passed the order. Both became as a part of the record. Order is out.
Keep going.
Yes.
26th, because this week we have already fixed some cases. That's the reason.
Well.
On 26th. Yes, Mr. Bhattakur. This will come for admission orders work.
Motion, my lord. I beg to mention item.
For motion, when did you file?
6/5/2024, my lord, earlier listed.
Mr. Goswami?
Hello.
So your matter is for motion or what?
For admission, notice was issued and it was served. There was in spite of my mentioning, it is not listed. There is urgency, that is why.
Not on 22nd, in that case, 24th.
This item number 28, your lordship. In fact, your lordship, this matter relates to your lordship. We have challenged the order taking cognizance, your lordship, on the ground of lack of sanction, your lordship. This, the other petitions, your lordship, in respect of the same petitioner is fixed on 8th of August, your lordship. Same issue, your lordship, but the different courts, your lordship. If it can be, your lordship, listed on 8th, your lordship.
What are the other cases?
Lordship, I will hand over.
Give the list along with that on 8th of October.
Lordship.
On the prayer of Mr. That's what I learned counsel for the petition.
The Lordship, I'd like to mention item number 44 of the bill. The Lordship, that item may be adjourned for the case.
I don't think so will reach. Anyway, we'll keep a note on that. Okay.
Deeply appraised.
May please, your Lordship. Lordship, I beg to mention item number 8 of today's list, Lordship. I have the instruction to withdraw this petition, Lordship.
Wait for a few minutes. After completion of the maintaining, we'll pass the order. Wait for a few minutes.
May I please, your lordship? Lordship, I pray for listing of an old pending criminal appeal against acquittal, lordship.
For what orders?
Yes, lordship. In the first week of August, any day, lordship. It's pending since 2018. lordship.
Make a mention on week commencing from 22nd, not today. Okay.
Obliged,
Date and the next week you make a mention.
obliged.
May I appeal, Lordship? Lordship, I beg to mention item number 30. 3-0. Lordship, in this matter, Lordship, the service with respect to all the respondents complete Lordship matter may be Lordship fees for admission.
Let's see, these are orders matter, right?
Order.
We may take up in the second half itself because some order matters are for some condonation of delay or something. We will get back to you. Wait in the second half.
Oblal.
Order matters will take up in the second half.
Oblal.
May clearest lordship, I am here to mention criminal petition for listing of withdrawal
With 12.
on Monday,
22nd,
26th.
next Monday.
Highly organized.
May I please your lordship, item number 3, matter may be adjourned for the day. My senior could not come.
Put order. See, on the stay order is in force since 4th of August 2022. Letter matter reach. Order discuss. Yes, next.
Met please, your lordship. Lordship, I beg to mention for listing criminal revision petition filing number 6137, lordship. Maybe on Monday, lordship.
Still filing number, not yet numbered.
Not yet number. Already been objection been complied, lordship.
Make a mention next week. Later it will be number. Yes, next.
May I please agree? My lord, I beg to mention item number 29, my lord. In this case, my lord, and I was there, my lord, for bail, my lord. That is not listed to the my lord. Kindly take up after 1 week, my lord, with IA, my lord.
Order matters will take up at 2 o'clock. Please wait for some time. The next one, we consider.
May I please, your lordship, item number 20 on admission, lordship. Can it be listed on next week, my lord? I need to go through, my lord.
Item.
21, my lord. Any date next week?
We can it to be fixed. Yes.
My lordship, may I please your lordship. I beg to mention item number 18 for admission. Maybe passable for the day.
Yes,
Please, your lordship, I beg to mention item number 19, lordship, LCR was called for, that is not received, lordship.
for 90. Act 2 will take the order matters, so inform your colleagues. Thereafter, we'll get back to admission again. So reminder, where is the office number 2024? So reminder to the Chief Judicial Magistrate come with matter. What is scanned copy of the records of CR case number 75022. List count.
Highly obliged.
Yes.
May I please, lordship? I beg to mention item number 26, lordship. For passover today. Your lordship.
We'll take it at 2 o'clock. Wait for your time. Yes.
May it please, your lordship. Lordship, I beg to mention item number 2 of daily list, lordship. Can it be passed over for the day, lordship? Conducting council, he has some personal difficulties, lordship.
Prepare counsel for the petitioner. List on. Twenty-nine.
Lordship, interim order plus earlier may continue to the next date, Lordship.
22nd. Till then.
Obliged, Lordship.
My item number 8 was there, Lordship. One. I think. Lordship, item number 8.
Oh, yes. Yes, you're right.
Section. I have the instruction to order this petition.
Administrator Borel and counsel for the. Additional session that from the government in special NDPS case number 01/2013 arising out of not DPS case number 109/2022 frame charge against the petition under section 29 of the NDPS Act, read with section 21 written bracket C. The same act. It's a public it out. By order dated 26/04/2023. Along with two other accused. The petition on 26/07/2023 filed this criminal petition saying amongst others petitioner named is already working to set aside in costs the proceeding of said special NDPS case number 1/2023 noted above. Notice in this case was issued on 28/07/2023. The respondent. No, your point. On the instruction of the petitioner, namely such and such, Mr. Bora, his counsel, is not pressing this petition. Accordingly, petitions are dismissed as not pressed. Malad.
Obliged. May I please, the Lordship? Lordship, in this case, Lordship, the matter pertains to dishonour of check, which was filed under section 130 and NI Act. And I will receive instruction that, Lordship, the dispute between the parties has already settled outside the court, and already the other side received the payment of the check also. And my client instructed me to file an application, I have before this honorable court under section 147 of NI Act. So may I pray for Lordship for 2 weeks to file that application?
Yes, what is the instruction?
Uh,
You have received the amount.
we already it is compromised and the party has received the amount.
2 weeks may be allowed, Lordship, we'll file.
What Mr. P.P. Bhattacharya, counsel appearing for the petitioner. What's your good name, ma'am?
Error.
And MS A. Roy. Client counsel for the respondent number 2, the complainant. Also heard Mr. B. Sharma, additional public prosecutor for the respondent number 1. Mr. Bhattacharya and MS Roy, client counsel for the petitioner and the complainant submitted. The matter has already been compromised and the complainant has already received the amount from the petitioner. An instruction of the petitioner, Mr. Bhattacharya, counsel prays for some time, prays for 2 weeks' time to file an additional affidavit in the matter. You want to file an application, 147.
140.
Request the page for 2 weeks' time to file an application in the section 147 CRPC. To which the counsels for the respondents have no objection. Placed on. August 13th. In the meanwhile, petitioner shall file necessary application as per.
Obliged.
Vasily. List on. The pair of the counsel for the petition. List on 24th. For admittal.
May I please, your Lordship? So this is a 482 application, my lord, wherein the petitioner here in my lord has sought for quashing of the FIR as well as the charge sheet, my lord. And presently the proceedings are being pending before the learned additional Chief Judicial Magistrate at Walpara. In this case, my lord,
Yes, sir.
in this case, my lord, here, if lordship comes to the FIR, my lord, FIR is at page number Annexure 1, my lord, at the running page, my lord, 24. Lordship comes for the moment. This is the FIR, my lord. Well, my lord, in this FIR, it has been stated that by the respondent number 2, inter alia, that therein that he had a joint family business under the name and style of Virginia Enterprise, dealing in broomsticks, that is jharu, my lord, and flowers, etc. On 9/4/2021, one Sri Sanjeev Saha, son of late Nani Gopal Saha, being one of his business agents, had contacted the petitioner Sri Krishna Dev for bulk supply of broomsticks from Dengao in the district of Karbi Anglong, Assam to Gwalpara, which the petitioner had readily agreed. Later, Sri Sanjeev Saha, after negotiating the price with the petitioner for supply of the said broomsticks, informed back the respondent number 2 Motu Sali regarding the same. Thereafter, on 9/4/2021, the informant respondent number 2 had rented a 12-wheeler truck bearing registration number WB11B8433 and sent the same truck to Dengao for bringing the broomstick as per the contract arrived at with the present petitioner. On 10/4/2021, the broomsticks were caused to be loaded upon the said truck, and after the truck got fully loaded and handed over the necessary transit documents, including the transit pass, etc., the informant respondent number 2 made payment of rupees 10 lakh cash through his mobile internet banking system into the petitioner's bank account, maintained at Axis Bank, Gwalpara, white number, account number so and so. It was the allegation of the informant respondent number 2 that after the payment of the said amount, the petitioner immediately fled away and from the scene and kept his mobile switch off. Consequently, the informant respondent number 2 had to unload the said truck on account of having failed to contact the petitioner. In such situation, the FIR was lodged, which was received and registered as Gwalpara PS case number 316 under section 420 and 406 of the Indian Penal Code. My lord, so far in this case, my lord, here, the petitioner, my lord, they have entered into a verbal contract with the said respondent number 3 for purchase of the broomstick weighing about 15 tons at rupees 13 lakhs, my lord. And the respondent had sent the 12-wheeler truck bearing registration number to Dengao in Karbi Anglong, and while truck reached the loading place, those articles amounting to rupees 13 lakhs were loaded, and after loading the said truck, the respondent number 3 had paid an amount of rupees 11 lakhs 10,001 rupee into his bank account maintained at Axis Bank at branch Hojai, and also promised to pay the rest of the amount after the said truck carrying those articles reached at unloading destination at Gwalpara. My lord, in between, I would like to submit that, my lord, the entire, my lord, here, the transaction, as well as the collection of the article which took place, my lord, it took place at Karbi Anglong, my lord. And those were collected from the local villages therein. And accordingly, the requisite transit pass in respect of the said vehicle carrying those articles were issued by the concerned forest officials of Karbi Anglong East Division Different.
Okay. Yes, what do you have to say?
My lord, in
This
fact, my
matter
lord,
relates to an agreement between you, maybe oral agreement, but the matter relates to supply of brooms, right? Certain amount has been paid, and as per him, as per the petitioner, certain amount is to be paid, according to him, no amount is to be paid, but you have not received that broom. Have you received the brooms or not?
no, that is the case, my lord. What has happened, my lord, after the amount has been transferred to his account, my lord, immediately he fled away from the scene. In fact, truck was loaded. At that point of time, he informed to me that due to the non-payment, the truck could not be moved from there. Immediately, when the amount has been transferred, the petitioner fled away from there. And the broomstick which has already been loaded, that has been taken back. And then the empty truck has come. The respondent number, that is the informant ballot, on the next day, went there to inquire about the matter, ballot. He could not contact even to the petitioner ballot. And then he waited for some times and then returned back, and immediately he filed an application before the bank that so and so happened. And the bank has freezing the account. And thereafter he lost an FIR. And petitioner also lost another affair against me.
And that we have seen, that has come for a. final
Yes,
report has
that
been
is
filed.
finally what has been submitted. My lord, in this case, prima facie, there is a case disclosing. So charge sheet has, after the due investigation, charge sheet has already been filed. So proceeding may be continued, my lord. If he has any case, well, he has placed before the trial court. This is not a case for quashing, my lord. Because prima facie discloses the criminal case, my lord, against it. And as per the information, my lord, he is the habitual offender like this. He seated many others person. Even then, my lord, thereafter, when he arrested in Gwalpara, he contacted with his agent to the informant that he will negotiate it after coming out from the jail. He will pay the entire amount and then he negotiate the matter. On the basis of that, my lord, at the time of his bail prayer, my lord, the informant has filed an affidavit that a negotiation is already going on. But just after come out from the jail, my lord, he again pleaded. Second time he seated. As a whole, my lord, this is a case not for quashing under section 482 CRPC, my lord. Since the charge sheet has already been filed and trial is just going to be started in the meanwhile, my lord, the interim order has been passed by this honorable court, and due to this, my lord, for last 2 years, my lord, the proceeding is stayed.
My lord, if I will be allowed to submit.
And even, my lord, for the several judgments, my lord, this is not a case for quashing. And his case has already been given final report.
Where is the search sheet?
Main petition, my lord, page number 53, my lord. 53, annexure number 10, my lord.
Proceeding was in what stage before passing the interim order?
My lord,
The proceeding was in what stage?
my lord, the proceeding was at appearance stage, my lord. We received the summons. My lord, so far this premises of the case, my lord, it tantamounts to a gross abuse of the process of law, my lord. So far our case, in the affidavit, my lord, we have,
We'll pass the order after some time in the second half. But before that, in the second half, we'll take up the order matters. And then
Well,
we'll
I have-
pass the order.
my lord, I have something to submit on this.
Definitely, we'll come back.
Much of this.
Where is the office note? Dated 26/06/2024. Registry shall issue notice on the response number 2 by issuing necessary newspaper publication widely circulated in the state of Assam, one of which shall be in English and the other in vernacular in the Assamese. Along with the copy of the newspapers in which such notice have been published. Sufficient notice on the response number 2. The registry shall list this matter on 21st of August.
May I please, Your
The
Honor?
report, just a minute. Regarding non-listing of the matter from 1st of August 2013. Since 15/05/2024. Is yet to be furnished by the registry. And the same shall be placed before the court in the next day. Yes. What's your prayer?
I beg to say that I'm on behalf of MG Singh, item number 26. He's out of station, my lord. So please pass over the matter for today.
Pursuant to the order. Dated 10/5/2024. The IA to put. IA আছে। ঠিক আছে। আর ফলে on declare the counsel for the petitioner. Matter is adjourned today. List on. Twenty-fifth. It is to be noted herein. The interim order passed earlier. On 02/09/2019. Was last extended on 27/11/2019. Which was up to 19/12/2019. Since 19/12/2019. There is no interim order in force in the present proceeding. Rest. Law, there is also no application.
May I please, your lordship? My lord, the matter is infectious, my lord. Already the proceeding has been dropped, my. The matter is infectious.
Why?
We have challenged the proceeding, my lord. Already the proceeding has been dropped by the trial court.
You have the copy of the order?
Hmm.
By which order it has been dropped? Any idea?
My lord, as per instruction, my lord.
What's your good name, ma'am?
And Nasrin, my lord, on behalf of Mr. M. Mondo.
Okay. Matter relates to the proceeding under section 145 public 146 preliminary 1 CRPC. The learned executive magistrate on 19/05/2022 passed an order in Miss case number executive magistrate Bilasipara. Respectively, passed an order in the Miss case number 008/2022. Notice in this case was issued on 05/09/2022. The respondents hearing. During the deliberation of the matter, Ms. Learned Counsel, on behalf of Mr. M. Mandal, counsel for the petitioner, submitted that submission on behalf of petition is submitted that during pendency of this criminal petition, the said proceeding number 008/2022 pending before the court of learned executive magistrate Bilasipara was dropped after hearing the parties. In view of the above, this criminal petition being in purpose thanks dismissed.
May I please? My lord, interlocutory application is there, my lord, for consideration of bail, but today not listed. Your lordship. Earlier it was listed.
Yes, anybody appearing for response number 2? It's a POXO case. Notice have to be served on the response number 2.
Pursuant to Honorable Court's order, my lord, 25/2024, my lord, we have taken steps pursuant to judgment of Deepak Nayak, my lord. We have taken justified this order, my lord. In this regard, we have filed affidavit, my lord, regarding completion of justice certificate.
The document certification to put circular from related to the in pursuance of the notification number 17 dated 15/05/2024. Sentence the appellant herein is a convict under section 6 of the POCSO Act 2012. And presently serving the sentence in terms of into judgment dated 08/02/2023 passed by learned session judge Karimganj in special sessions case number special sessions case POXO 05/2020, in which he has been sentenced to suffer rigorous imprisonment for 10 years with fine of rupees 20,000, in default for the simple imprisonment for 6 months. Next. Pursuant to the notification number 17 dated 15/03/2024, a convicted appellant is allowed to take steps under response number 2 by serving a copy of this memo of appeal on the public prosecutor, Guwahati High Court, Guwahati, obtaining necessary acknowledgement for it on or before 23/07/2024, obtaining necessary acknowledgement of Radhika. Thereafter, to the officer in charge of Patharkandi Police Station, District Karimganj, shall serve notice on the response number 2 public informant of the concerned Patharkandi PS case number 81/2018, within bracket GR number 523/2018, bracket close, quarter bracket here, PRC number 1398/2019. In her address, Nehrun Nesa, NEH, Nesarun Nesa. No. Nesarun Khatun, NESARUN, Khatun, KHATUN, wife of Mohabbat Ali, resident of Kolkoli Bosti, KOL, AAL, KALI Bosti BASTL. Police Station, Patharkandi, District Karimganj, within bracket likha, mobile number 6900598668. Officer in charge of public notice to respond number 2, the complaint in charge, obtaining necessary acknowledgement. Thereafter, the officer in charge of Patharkandi Police Station shall submit its report regarding sufficient response number 2. Report registered judicial, Guwahati High Court, Guwahati. List on 28th of August. Yes,
Along with IM, my lord, along with IA 262 of the,
that will consider, no
my
problem.
lord,
But serve notice on the public prosecutor, Guwahati High Court,
my lord,
on or before Tuesday.
my lord. All right.
Your Lordship. Lordship, in this case, it respect of all the respondents. Lordship, service has completed, Lordship. Madam, may be pleased for admission.
Where is the office note dated 07/22/01/2024? Sorry, I got it. 07/12/2023 and 22/01/2024. Service of notice is complete on all the respondents number 2 to 10. Registry has also received the relevant records from the Court of London, Judicial Mills at first class from Book Metro. Since the service of notice is complete on all the respondents, list the matter for admission in the week commencing from 5th of August.
My Lord, my Lord.
The date to be fixed by the registry.
May I please, Your Lordship? The LCR has already been received, my lord, and so far as respondent number 2 is concerned, service of notice, the edit shows that address has found the notice, my lord.
Where was the office note? The date 10/8/2023. Both the office notes of 10/8/2020, 10/8/2023 and 19/08/2023. Service of notice is complete in all the data from number 2. Sorry, as 1 and 2. This appeal was already admitted for hearing on 16/06/2023. The registry has also received the relevant records from the Court of London Additional Session Judge Shipsagar. Both the appellants are on bail pursuant to the order dated 18/09/2023, passing connected IC, a criminal liquor, 4882023. List this matter for hearing. Registry shall list this matter for hearing.
Of the
On the date to be.
But in this case, service is complete and LCR has also been received.
Oh. In this case, matter already, there was granted LCR hearing. This for hearing, madam. So, whole লাগে তো।
Yes, Mr. Look at this. It was not pointed out before the court while passing the order. The informant, the matter relates to POCSO.
Not POCSO, madam. 376 3, madam.
276.
Yes, not POCSO. It was there initially, my lord.
Okay, 276-1.
Yes.
Then not it.
Yes, ma'am. Initially, it was charged of him, madam. Conviction is not under POCSO.
From the
Yeah,
also
yes.
you, sir.
Yes. To prove that victim was 14 years old, and therefore trial for it, people do not want to file the petition. And the evidence is related to the one that section 2 also. However, we can go.
There was the office note, there 19/03/2024. Matter be placed before the Lodging Court for necessary order. List on. August 19. For modernization, Lodging Court, 450.
All right.
May I please, your lordship? Lordship, in this case, the impugn order dated 28/6/2023, that is passed by Lanet Sizem Bongaigaon in the corresponding case number 19 of 2022. The Lanet Sizem has rejected the prayer of the petitioner in petition number 863 of 2022. In this case, my lord, the FIR has been submitted by the IO. But the police do not find any sufficient evidence for against the alleged under section 342, 294, 507, 34 as registered in the FIR.
So, see. Service. Police. That's when I'm police.
Government of Assam. Oh, it is complaint.
Police, police officer.
No, no, no. I have to complain and
আমি কেনেকে notice
complain. মই
Sorry.
জুলি দে কাৰণে
সেইটো বুজি পাইছো।
Where is the office note? There is 2023. The registry has already received the relevant records from the learned Chief Judicial Magistrate Bongaigaon. However, service of notice to respond number 2 is not yet complete. From the reports of the report of the case, it is seen that the address of the respond number 2/informant is dash Nicola. Sorry, Utpradhar, SARML, SUTRADHL, wife of Utpradhar, resident of village Gaon. Resident of XY DAR, Gaon. Police station, Bongaigaon. But never do. The Gaon, Comadia, Digdari. DIGDAR. Police station, Bongaigaon, district Bongaigaon. Has been revealed from the affair of the police. Mobile number 60010889007. Petitioner shall take first steps for service of notice on the respond number 2 informant in the above noted address on or before 23 by registered post utility providing its current on or before 23/07/2024. List on 21st of August.
Highly obliged, my lord.
May please lordship. In this matter, my lord, the legal aid counsel and the secretary.
Just a minute. How many days delay?
My lord, even really, and the same in this matter.
Huh?
I have not checked the file. My lord.
Yeah, my guess.
There are petition process.
No.
Legal.
You are appearing on whose behalf?
Miss M. Das, my lord. She is not in station.
Just a minute. The convicted appellant preferred this appeal. Preferred the connected appeal from jail. But the judgment and order dated 22/02/2023 passed by the learned special judge in bracket Poxo Soraidu convicted informant was served on her by the Sub-Inspector of Police, Temangapukuri Outpost under Mothurapur Police Station of District Soraidu on 07/06/2024. But the said respondent number 2 remain unrepresented. The applicant could show sufficient reasons for the delay of 15 days in preparing the connected criminal appeal against the judgment and order dated 22/02/2023 noted above. Considering the delay of 15 days in preparing the same appeal, the connected appeal is hereby accordingly found. The registry shall register a number the connected criminal appeal and shall list the matter for admission in the week commencing from 5th of August. If in the meanwhile, the respondent number 2 informant doesn't appear in the matter, the said respondent, the court shall consider to engage and I might report the said respondent. Okay, তারা কত লিখিত hard opposite.
That's all right.
Mr. Saika informed Ms. Das
My lord.
Please take on behalf of Mr. M. Yes, on the three.
May I please your lordship? Well, the appearing counsel, he is not present today, my lord.
Just a minute. So that's what you need. ASI has submitted the FIR. You will represent. Public
And my lord, notice of motion was issued, I think, my lord, and my lord, some stay order is there, as it appears from my.
Yes, it is there. Since
Well,
August
that means
2023,
investigation has been stayed, my lord. That means investigation has been stayed.
It has been stayed,
Or let it come up for admission, my lord.
but it has not been extended
After returnable date, my lord.
after returnable date, 26/09/2020.
My lord.
It has not been extended after return. No longer in.
Next time, let it come up for admission, my lord, on that day,
Yes,
my lord,
yes.
entire matter can be disposed of.
Where was the office note? That is 05.
I will represent the respondent number 2, my lord.
It is seen that the affair of the case was lost by the respondent number 2 in his official capacity. As such, the respondent number 2 is also represented by the learned additional public prosecutor, the state. Hardly killed. So initially, when notice was issued on 01/08/2023, the court passed an interim order staying the further investigation of the case relating registered under the basis of a FIR dated 10/06/2023 under section 471 of the IPC. Related section 13(1) of the Assam Cattle Preservation Act 2021 relating to Katwal Police Station case number 35/2023. But after the returnable date on 26/01/2023, since 26/01/2023, there is no stay order, there is no interim order in the present proceeding. Place this matter for admission in the week commencing from 5th of August.
My lord, another matter, item number 7, my lord.
Item number?
7, my lord.
Ah.
My lord, Mr. A. Soma is appearing in that matter, my lord. Maybe taken up some other day because he is not today, my lord. Other side is, my lord, here.
Where in Itanagar?
My lord,
Where in Itanagar? Where is he? Ashim Sharma or Angshuman Sharma?
A. Sharma, no, Angshuman, not Angshuman Sharma, my lord, Asim Sharma, my lord.
When to be listed?
Any day, my lord.
Okay.
Number 7.
On 29th.
Lordship. Deputy Obligation.
None appeared for the petitioner on call. Though Name of the council has been reflected in the court list. From the office note dated 03/04/2024, it is seen the petitioner is yet to take steps on the response number 2. Though the court on 4th in 2023 directed the petitioner to take some steps on the response number 2, rather is the proceeding. Even on 07/03/2024, the Lordship of Court directed the petitioner to take steps on the response number 2 by within 7 days from today, 7 days from the same date. But the petitioner did not take any such steps. Failure on the part of the petitioner take steps on the response number 2 on or before second of August. On or before 2nd of August. This proceeding itself. Without any further order of the court. And this may be
The IA is my lord for condemnation of delay 198 days. So may I pray for a notice to the in the IA my lord in preparing the revision my lord. IA to delay condemnation 198 days my lord.
the applicant as petitioner preferred the connected criminal division petition being agreed with the judgment dated 14/03/2023 passed by London Additional Session Judge Hailakandi in criminal appeal number 56/2019 upholding the judgment and order dated 19/08/2019 passed by London Chief Judicial Magistrate Hailakandi in jail case number 970/2016 convicting the applicant / petitioner under section 447/323/34 IPC. What is the order? We released him or convicted him?
Convicted my lord, but the release
But
on
released him
under the probation of offenders act my lord. Conviction
under
is there.
section 3 of the Provision of the Offenders Act. Probation of Offenders Act. But directing him to pay a fine of rupees 3,000 towards compensation under section 5 of the provision of Offenders Act 1958, in default to undergo simple imprisonment for 15 days. While filing the said criminal revision petition, there's a delay of 198 days or
198 days, madam.
198 days. Hence this application. For delay of, for continuation of the said delay. It's a notice. Returnable by 6 weeks. As, what you are appearing for whom?
APP Ashram Lordship
What's
and
your
thus,
name?
and thus Lordship.
I'm so sorry. Take a consult for the petition and make such and such. Additional clarification for the opposite party number 1. Yeah, such and such accepted notice. No problem. Petition to make it extra copy of this petition. To be submitted on or before 23 of the necessary. Petitioner shall take steps for submittal notice on the register number 2 by registered court of AD, providing a correct and purported to the register on or before 23/07/20. It's a notice to the returnable by 6/6.
Obliged.
May I please? In this case, my lord, already my lord, informant has appeared. This
You
was
are appearing for the informant.
Informant, not a matter, informant.
Lord, at the chief says, my lord, I pray your lordship to adjourn the matter for the day, my lord.
You have not filed any objection.
No,
No, Lordship.
You have also
No,
not filed, why?
No, Lord.
You are not filing over.
Lordship, punishment is 7
7 years,
7 years, Lordship.
not mandatory.
Are you not filing objection for bail?
For 7 years, Lordship, not mandatory.
Not mandatory.
Less than 10 years.
Okay. Later. Third, Mr. J. Islam, counsel appearing for the applicant.
We are not excluded by habits.
NMS, such and such. Plan revision for the prosecutor
We are not political.
for the arrest number 1. What's your good name?
SK
Blood counsel for the arrest number 2. The applicant as an appellant has connected appeal. The criminal appeal number 455 of the 2022. The appeal for the judgment, impugn judgment and order dated 17/10/2023. As well under additional session judge William Beckett. Come special judge Beckett Nalak. Oxo Borpeta. In special case number 09 of 2020. By which he has been convicted under section 363 APC and 63. Sentencing him to undergo rigorous imprisonment for 4 years with fine of rupees 5,000 in default, simple imprisonment for 6 months, and further under section 4 of the POCSO Act, sentencing him to rigorous imprisonment for 7 years with fine of rupees 10,000 in default for in default. Simple imprisonment for 1 year. Another 1 year. The said appeal was already admitted for hearing by order dated 13/12/2022. By this application, the petitioner has paid for suspension of the imprisonment sentence passed by the learned circumstance in said special Foxtrot case number 09/2020, and to release the applicant on bail. That was the found. Let's take your seats. Let me go through the evidence. on the records that was called for by the court earlier. The relevant record was called for. It is seen that on his surrender, the applicant was taken into custody on 13/11/2017. In connection with Baghor Police Station case number 287 of 2017. During the trial of the case, the applicant was released from jail on 25/01/2020, 2018, as he was granted bail by Learned Special Judge Pokso Barpeta on 24/01/2018 in Said Baghor PS case number 287 of 2017. As the applicant after opening bail did not appear during the trial. On the strength of the non-bailable warrant of arrest issued against D 126-07-23, he was again taken into custody. Later, by order dated 16/8/2023, this court released him on bail in BA 2845-2023. After passing of the interim order, judgment and order of conviction dated 17/10/2023, in special POCSO case number 09/2020, the applicant was again taken into custody on 17/10/2023. And since then, he is serving the interim judgment and order of conviction. It is seen from the records, the case that during 164 statements made by the victim before the magistrate, on 7/11/2017, and the judicial is on 7/11/2017, as well as in our evidence before the learned special judge. The victim categorically stated that the applicant, the pretext of dropping him in her home from the school, took away to a different place, kept her forcibly kept her with him for 2 nights and committed rape on her. It is also seen from the birth certificate of the victim that at the time of the incident, victim was less than 16 years old. Considering such materials in the case diary, in the records, the court is not inclined to grant bail to the applicant convicted accused appearance in said such and such case number at this stage. Accordingly, this application for bail of the petitioner, it's a suspension of the sentence such and such. The bail of the applicant person in said particular stands rejected.
But I will be here, people here. Main appointment.
This appeal was already admitted for hearing by order the 13/12/2022. Registry has already received the relevant records from the Radiba. The service of notices complete on all the respondents has since the informant respondent, the respondent number 2 informant has also entered appearance in the matter. Registry to list this matter for hearing. In serial court. Right.
My pleasure. Individual petitioner was convicted under 376, we prepared a bail petition. No, we have prepared a note on bail. May I pass it at your lordship? If your lordship goes to the judgment, it will appear that in the case of acquittal, either it is a case of acquittal or the victim is a consenting party. Merely by going to the judgment, it would appear. At least it appeared to me.
Mr. Dasgupta, what we have seen from the office note that a notice on the respondent number 2.
So it was taken on in the month of March, no?
No, that's true. What we are doing is, since it was sent by registered post,
The AD
we
not
place the
returned.
matter before the Lozima court and obtain an order. Thereafter, we will consider this because records have come and everything is there. We will consider your bail. Let the report come from the Lozima court first. Where was the office note dated 15/7/2024? It is seen that pursuant to the order of the court, with 13/03/2024. First steps was taken on the respondent number 2. By registered post of the AD on 20/03/2024. Place this matter before the Lozima court for necessary order. Put it for you. Matter be placed before the court again on 7th of August along with the report of the Lord Zimmerman. We'll consider underneath.
All. My lordship. I will not tell, I will.
Let's move. On last occasion also, nobody appeared, I think, on 24/6/24.
Foxo case stayed without hearing the informant. But
Recalling of witnesses, my lord. Yeah.
true, but the
Basically.
proceeding has been stayed.
Well, that is a serious thing, my lord. Yeah.
Difficulty, these orders have been passed in presence of the public prosecutor. If the public prosecutor doesn't state it before the court, Mr. Das, that's why your team must create.
Yes, yes.
Because see, the council will always try to take the advantage. Unless the public prosecutors makes an appeal for the court, the duty of the public prosecutor. But
Ongoing trial is stalled, my lord.
now legal aid council was again for the petitioner. No. How come?
On 24/6/24 also none appeared.
Manish Kumar Das, legal aid council. Any idea?
Well, now my learned friend is appearing as legal aid counsel.
No, for the petitioner.
Oh, petitioner. Manish Kumar Das. Dibrugarh. Well, I am told by my learned friend he is from Dibrugarh. Legal counsel will file.
If he is from Dibrugarh, how can it be engaged by Guwahati High Court?
Yeah, that I do not know. That practice corner.
But later appointing him as a legal aid counsel is also not here. The petitioner hearing is represented by a legal aid counsel namely Manish Kumar Das. However, Dr. Tita, notice in this case was issued on 16/11/2023. And the court in the interim state the further proceeding of POCSO case number 145/2021 pending before the Court of Learned Additional Session Judge cum Special Judge POCSO Morigaon till the returnable date. However, after the returnable date since 1/4/2024, the said stay order has not been extended. Stay order dated 16/11/2023 has not been extended. From the order sheet, it is also seen that on last two occasions, the petitioner remained unrepresented. Even today, when the matter was called upon, the petitioner remained unrepresented. The court on 24/06/2024 observed that on the next date, if the petitioner remains unrepresented, an appropriate order shall be passed. Heard Mr. D. Das, learned additional public prosecutor appearing for the state. Respondent number 1. And Mr. P. Saikia. You are amicus curiae legal aid counsel. Legal aid counsel for the respondent number 2. The Assam State Legal to the Guwahati High Court or Assam?
Guwahati High Court.
The Guwahati High Court Legal Services Authority
Legal Service Committee.
is directed to appoint a fresh legal aid counsel on behalf of the petition. Register Judicial shall bring it notice of this order to the Guwahati High Court Legal Services Authority, for which place this matter again on 29th of July.
May I plead your lordship?
Yes.
482 application, your lordship, for quashment of proceeding, your lordship. The petitioner before your lordship is a 75-year-old lady, your lordship. On last occasion, your lordship was pleased to direct the respondent to bring instruction, your lordship, regarding the informant's whereabouts.
Informant two is,
I'm appearing.
yes, yes, you are
The
appearing.
only thing, my lord, she has said that, my lord, she will have no objection considering her age, my lord. Only thing, my lord, the petitioner herein, my lord, may not disturb her again. Now she is residing in her own village and a portion of the land has been allotted to her.
So the
But those are land part, my lord, I am not submitting.
petitioner is a
Only that part.
75-year-old lady, your lordship. The police in the search sheet has already said that they could not arrest the petitioner because due to her illness, your lordship.
See, cannot be quashed. The reason is 498A, anything has to be on the basis of the evidence available for the trial. Many judgments have been passed by our High Court as well as by the apex court. 498A, if the maybe proving ability or whatever, it has to be proved on the basis of the evidence available before the trial.
But your lord,
Simply cannot be because we have already seen certain materials here. It is true you, because in the search sheet itself, considering your age, you have not been arrested.
yes, your lordship.
And let the trial proceed and
Your lordship will,
funding will be there.
your lordship will kindly go through the FIR, your lordship.
We have seen,
Yes, your lord, there is no specific allegation, your lordship.
question is not there. See, after the death of the husband of the petitioner, the informant, not the petitioner. See, the record itself reveals that she had to leave her in-laws, her matrimonial home.
Yes,
And thereafter, there was a meeting
Yes, Your Lordship.
in which she was allowed to take up on certain rooms,
Yes,
which you have already given those rooms on rent to somebody else,
Your Lordship.
right? So, questions are there. So all these materials, they definitely court is not interested, but considering is you will definitely, when the investigating officer in the search sheet itself has mentioned
Yes, Your
that
Lordship.
considering is of the particular petitioner, who is also an FIR named accused, she has not been arrested. It's there, will not be arrested, but the trial will continue.
Your Lordship, there is no, Your Lordship will kindly go through the
Yes,
FIR.
see.
There is no specific allegation, Your Lordship. Offense
Why
under
she had to leave?
498A.
Why she had to leave her matrimonial home? Those things can be considered. That is the cruelty. Husband expired,
Yes, Your Lordship.
and the respondent number to the informant. She was no place for her to stay in her house or matrimonial home. She had to leave.
Yes, Your Lordship.
Under compulsion, she had to leave her matrimonial home. Don't you think it's a cruelty?
But the present position is, Your Lordship, the mother-in-law has to leave the house, Your Lordship.
See,
This is the
already
present position, Your Lordship.
that we do not know. The mother-in-law has, that is, present petitioner has sold land. Petitioner has also given, as far after the meeting of the villagers or whatever they are staying, she was allotted few rooms out of many rooms. Right?
Yes, Your Lordship.
So,
But Your
want to
Lordship,
place any judgment?
yes, Your Lordship.
Leave it
When
to
there
us.
is no specific allegation, Your Lordship, the Honorable Supreme Court,
Specific allegation of cruelty, how it will be proved?
because,
There may not be any physical torture. Husband has expired
yes, Your Lordship.
and she was thrown out of her matrimonial home.
Yes, Your Lordship.
Why?
But
Is
in
not it
the
a cruelty?
FIR itself, she has stated that the 4 numbers of room has been allotted to her, Your Lordship.
How many rooms were there? We do not
6
know.
rooms, Your Lordship.
It
4
is
has
very
been
clear.
allotted to her, Your
It is
Lordship.
very clear that she had to return back. Only when the villagers in the meeting and then decided to give few rooms to her, then only, otherwise she had to leave her matrimonial home.
Yes, Your Lordship.
Then those things can be definitely, it's a cruelty. As because the son has the mother-in-law throw out her daughter-in-law. Is that the law?
But the present position is she is residing in the house, Your
That is a
Lordship.
different issue. Let the petitioner rise, file another affair against the respondent number 2.
So I'm relying on this 2012-10
Okay, we'll consider, we'll consider.
para 25, Your Lordship. Relevant para is para 25.
Yes, Mr. Gogoi, what is your submission?
But whatever she has now submitted, you can, at the time of framing of charges, she can raise the issue. And regarding the age also, if we go by the merit. Dispensing the personal appearance, that part, my lord, she can always, my lord, make a submission. On the merit of the case, my lord, of course, my lord, let the trial court decide. I have nothing to say on that part.
Heard,
For passing, my lord, to
F. Hussain, learned counsel for the petitioner. Also
but on the
heard,
last occasion, since the direction was made, I have got the instruction. My lord, that's fine.
also heard. Mr. D. Das, learned additional public prosecutor appearing for the state, respondent number 1. And Mr. B. Gogoi, learned counsel for the respondent number 2. List on. List again. On 7th of August for necessary order. Okay. Report here.
Your Lordship, the next date fixed on 22nd, Your Lordship, on
22nd what?
of this month, Your Lordship.
Okay, inform the court that the matter is pending and is fixed again on 7th of August.
Yes.
Over.
Oblige, Your Lordship.
The Lordship. Lordship will take a step upon the respondent number 4, my lord.
When did you take step on the respondent number 4? There is a direction from the Lozima court to take steps on the respondent number 2.
My lord,
Respondent number 4. We have not taken it.
my lord, actually, we did not know when the listing, my lord.
Peruse the order of the Lozima Court dated 07/03/2024. Also peruse the office note dated 03/04/2024. Petitioner shall take first steps for subject of notice on the respondent number 2, person number 4, on or before 23/07/2024. By registered posted edit. Providing is correct and proper address with requisite postal stamps. List up to 6 weeks. And then it to be fixed by the registry.
Publishment.
Your Lordship, as per office note dated 17/7/24, your Lordship, the notice or AD has not been returned back, your Lordship. Kindly await service report, your Lordship.
Peruse the office note dated 17/7/2024. Await service report and respondent number.
Sole
Yes, please,
responsibility.
where steps were taken only on 28/06/2024. List on 9th of August.
Your info on the past earlier may continue, your Lordship.
It has been there only.
Yes, your Lordship. Oblige, your Lordship. May I please, your Lordship?
Before somebody mentioned in the morning.
Yes, your Lordship, I have mentioned for an adjournment. My senior is out of station for today. And
Why it has been listed today? Any idea?
yes, sorry, Lordship. Notice has been sent to the respondent number 2 and
The, where is the office note? Registry has already received the relevant records from the special Jazuddin Beckett Poxo, Musalgaon Boxer. The appellant is allowed to take steps on the respondent number 2 informant. In terms of notification number 17 dated 15/03/2024 of this court, of this High Court. By serving copy of this memo of appeal and the public prosecutor, Guwahati High Court, Guwahati, by obtaining necessary acknowledgement. Thereafter, the public prosecutor through the Such on or before 23 listening. Located on or before 23/07/2024 obtaining necessary acknowledgement. Thereafter, the office of the public prosecutor to the officer in charge of Tamilpur police station shall take steps on the said respondent number 2 informant Sri Lokrasia Tigga Srimoti Lokrasia wife of Francis Tigga, resident of village Botiamari, post office Komarikata, police station Tamilpur, district Baksa. Number 1 Botiamari, no? Lokrasia Lakrhachi. Thereafter, the officer in charge of Tamilpur police station shall submit a report regarding servitude notice on the Register Judicial of Guwahati High Court property. Petition mentioned that number 2 list on 19th of August. Mr. As, do you have a proper office to issue notice to the authorities, police stations, because this notification is important. It has to be received duly and pass orders. Where is the office note?
Lordship, notice
It
that
is 16/7/2024.
sir,
It is saying that the respondent number, the sole respondent
so that
refused to accept the notice of this proceeding. In view of the above, it appears that the notice is still served upon the petitioner of the said respondent, as he was aware of the contents of this case. In view of the above, service of notice of the sole respondent number, sole respondent is complete. Place this matter for admission in the week commencing from 5th of August, on a date to be fixed by the registrar.
obliged.
Meet with your lordship. My lord, it appears from the office note that answer notice has been received back, my lord, from, for which was issued for the respondent number 2, with a postal remark as address is not found.
To take the steps.
My lord, yes, my lord. Wait, it only address known to me, but my lord, if your lordship peruse the page number 24 of the criminal appeal, there is one more address, my lord, which the respondent number 2 himself mentioned. So, my lord, I may be allowed to take steps in the other address as well. Page number 24, below part of the FI.
What is his name? Waizul Islam.
My lord.
Here is the office note, dated 20/06/2024. The appellants are allowed to take press step for service of notice on the informant respondent/informant number 2 by registered post UTD on or before 2304. Paribani 24. 24 করে দিই। একজন 23 পরিচয় আছে 24/07/2024 by registered post OTD in his address, in his both the addresses at as Dastia, Wahidul Islam, son of Hussein Ali, resident of village Madhupur, post office Madhupur, police station Gormur, district Majuli, as well as Wahidul Islam, son of Hussein Ali, resident of Muhammad Hussein Ali, resident of village Goroimari Gaon, police station Lahori Ghat, district Murigaon. Okay? Wedding is correct and proper address to the and the proper additional again, register postal stamp, requisite postal stamp, list after 6 weeks.
Deeply objective.
Yeah.
Both the respondents, lordship, sir. One is state and other is husband of the petitioner. So one.
Where is the office noted at 17/07/2024? Steps on the respondent number 2 was taken only on 20/04/6 in the wage service report, placed on 7th of August.
Obliged.
May I please, Lordship? Lordship, service yet for respondent number 2, my lord.
Where was the office noted at 17/7/2024? The notice on the respondent number 2, return answer with insufficient address. Petitioner is allowed to take first steps on the service of notice on the respondent number 2 on or before 24 by providing her correct and proper addresses with requisite postal stamps. List after 6 weeks. Get to be registered. Bilik pellets.
May I please, before Lordship, in this case. Well, you see.
May I please, your lordship? As per the office note, lordship, service report is awaited to the respondent number 2.
Petitioner shall take, where is the office notes? The date 29/05/2024. Petitioner shall take 29/17/7. Petitioner shall take first steps for service of notice on the respondent number 2 on or before 24/07, providing her correct and proper address with requisite postal stamps. Registry shall issue reminder to the London Judicial Magistrate First Class Sankardev Nagar for the scanned copy of the records of PRC case number 506/2024. on the basis of, it was registered on the basis of Doboka Police Station, case number 14/2024. Put in bracket, GR number 116/2024. Placed on 21st of August.
Lordship, interim order is there.
Till and the interim order passed earlier on 20/05/2024. The interim order passed earlier shall till then, till already, subject to the condition that the petitioner takes steps on the respondent number 2 as directed above within the time so specified.
Obliged.
Yes, you have to make some submission. Give us the
Lordship, I would request some time for taking up this matter, my lord, on any other day, my lord, because today I'm a bit short on some certain judgments which I would like to place reliance on for the purpose of in support of my case, my lord. So Lordship, any day, my lord. Because my lord, I do have a case, my lord. Because my lord, there are some intricate facts, my lord, involved with this petition, my lord, that which
We are supposed to look into it in 482 petition. Should we make a roving inquiry in a 482 petition?
My lord,
Whether the court, while exercising their power under section 482 CRPC, is supposed to make such roving inquiry.
because my lord, my case here is totally, my lord, there is an abuse of the process of law because
That's
so
your
far as-
submission.
Yes.
That's the submission of the petitioner,
Yes.
right?
Yes.
Always by using 482, you will say that abuse of the process of the court. But it is apparent that you have received the amount.
But so far, my lord, as regard to the transit passes and all which we have annexed in the petition, my lord.
That transit pass was also forced.
Yes, my lord.
My lord, those were being, the
So
articles
that
were
is
being.
why we'll look into it during the trial only, not by the
Yes,
this court exercising 482.
Yes, cannot.
How can these matters can be looked into at this court without there being in a trial? Whether it is forced or not, this court will look into it.
This court will
Then,
look into it, my lord.
if that is the issue, it is apparent. The case there reveals that it was forcibly obtained.
My lord,
And it was at the instance of one person whose name it was obtained. He came in before police and said it should be rejected because I have never authorized anyone to do that. So the petitioner has whatever. That is the reason we are saying that things cannot be. That is why it is a clear thing that while exercising the power under 482, the court will not exercise a roving inquiry.
Yes.
So it amounts to what? The entire proceeding. Anyway, if you want to place certain materials, you
Yes,
can place
yes.
it, will allow you.
Yes, yes, yes. That opportunity will be given to me.
Okay, on Wednesday next,
Yes.
on the prayer of the council for the petitioner. List again on 24th. For us.
Yes. Much.
No representation on the petitioner on both. Reaction. So you're here.
This case, my lord, award has been given 4,000, my lord. Maintenance. And I have filed this, my lord. In what heaven is this case, my lord?
Today not possible. We have another meeting at 4:45. What will, I will give you some time. Next day, please. এটা item আছে। এটা কাম কৰি 26, 29, 31st ভগাই দিব। 26, 29, 31 না? তাৰে মাজত ভগাই দিব। গোটেইকেইটা ভগাই দিব। টোটেল কেইটা আছে এডমিশন? সেকেন্ডত নাৰাখিব। কেইটামান ফিফ্টত দিব কাৰণ আৰু বেলেগ এডমিশ্যনো আহিব 14 বুলি ক'লে ন তিনিটাকে দি কৰাই দিব বাকী কেইটামান লাষ্টৰ চাৰিটা পাঁচটা প্ৰথমতে তিনিটাকে দিব প্ৰথম তিনিটা বাকী পাঁচটা Okay.